graduate of BSU and University of Idaho, and born and raised in Boise. Humbly welcome him.
Good afternoon. Thanks to Elizabeth and Ellen for their hospitality, the joy they always bring to an event. And they are two very busy, very well organized, and two beautiful people that I've known for many years. And I saw this bumper sticker, and I love it. It's a Republic. Now, you can't impress this upon this society enough that we live in a republic. And that's important. I just want, my task here today is just to take a few minutes to cover the third branch of government. And that is obviously the judiciary. That is the branch in which the government of the United States, the government of the state of Idaho, interprets the law and how it has been handled by the legislative branch, interpreted and enforced by the executive. What is being handed out to you presently is a copy of Federalist number 78, which was written by Alexander Hamilton. Now there are three. I really admonish you, especially as young as you are here in this room, to read the Federalist Papers. They contain the thinking of many of the founding fathers of our country. James Madison, John Jay is one or two of them, and Alexander Hamilton. And there's two. Take a pen out and write this down. There's two in particular that are important to the American thought: Federalist Paper number 10 and Federalist Paper number 51. Now, for you students out there, it's really important to understand, if you look at the document that's giving to you, this is a trick I did in school. What I do is I take the paper and I download it, and always leave a space for my notes. So it's something to think about. A good student will always be able to write notes, and because it's their thinking processes that you're writing down. And one of the most powerful methods of learning is to take good notes and put them in where they matter alongside the text. So that's just a teaching thing. But Federalist Paper number 78, does anybody know who wrote it? Hamilton. Hamilton's thinking, because Hamilton has quite a history. I'll leave that to someone else. Very colorful fellow. And he and Thomas and Jefferson, I'm not going to apologize for this. Thomas Jefferson is one of my favorite politicians in American history. He stands basically for freedom. And that's not my purpose here today to go into Thomas Jefferson. But I want to talk about the judiciary department of our form of government. There are two levels of government. There's the federal system, which includes all the United States plus the national government, implemented by a Constitution of the United States, of limited powers and authorities granted to the federal government, with functionally, at least at the time of the forming, the states were only limited by their own constitutions, by their power and authority. So when the first branch of government, called by James Madison, and in fact, as well as Alexander Hamilton, is the one closest to the people. Which one is that? Congress, the legislature. And which branch of the legislature is the closest to the people overall? House of Representatives. And the Constitution says that all powers of spending and taxing come out of the House. Why is that? Because the primary authority. Yeah, because it's closest to the people, and the people have the will of the people is being expressed on the floor, or the well, as they say, of the U.S. House of Representatives. Same here in the state of Idaho, at least theoretically. It's important to keep that in mind. So the legislature passes a law, then it goes to the executive. And then what does the executive do? He or she agrees or disagrees with it. If they agree with it, it becomes law, right? And then it's implemented by the executive or the president or the executive branch, in this case, the president of the United States, or his agencies, which we call the fourth branch, unfortunately. That's for another discussion. But what happens if, in implementing the law, one of his lieutenants or his administrators executes it wrong or misinterprets the law as written by the Congress, which was an expression of the will of the people? What happens then?
Goes to court.
Go to court. I think what we lawyers call is an aggrieved party. That's simply an expression of the meaning that someone who has been hurt by the implementation of the law or by an act of another person. And that aggrieved party files lawsuit and wants the law interpreted. And so that oftentimes the disagreement is over how the law is to be interpreted, and they want the courts to go back and look at it and say, did the Congress mean this? Or the state legislature mean this the way it's being implemented? So as Alexander Hamilton says, that the courts, one of the tasks of the courts is to check against wrongful execution of the law, especially where it's misinterpreted. And it's a kind, he doesn't use this term, but it's kind of a court of equity sometimes. That when they're to go look at a law that's wrongfully executed, we're asking a judge to go back and look at the Constitution, look at its implementing nature, and see if the implementation is correct. And then in a case, they grant relief. They either provide an injunction against the president or a governor, or provide monetary damages as a result of that wrongful interpretation, and order the executive branch to stop them from doing what they're doing and executing that law wrongfully. One of the things that, and what I would encourage you, I told you the 3, again, Federalist Papers, I encourage you to read. I encourage you to get all 85 of them. They have books. But it's number 10, number 51, and number 78. 78 is the expression of, on the third branch of government. It's in 78 that actually Alexander Hamilton mentions that, you know, the Constitution, understand, has nothing about judicial veto, or rather judicial check against the executive branch. Or in other words, where the court says a given act of Congress or the way the executive branch implements a particular law is against the Constitution. That's not in the Constitution. But it was argued at the time of its implementation. And in an article dated, well, within the year of the adoption of the original draft, September 17th, 1787, he argued in an article that limitations of this kind, which he's expressing with regard to checking against government, can be preserved and practiced no other way than through the medium of the courts of justice. Limitation being a check against the powers of the executive and Congress, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. In other words, if there's a law that's against the wording of the Constitution with clarity, they will void that law. That's one of the purposes of the courts. It's not just to deal with causes and controversies among parties and states and people of the United States and people of foreign nature, but sometimes it takes a challenge to bring to the courts to get a law reviewed to see whether it's constitutional or not. So that then finds its expression here. There was great disagreement over this at the time of the implementation of the Constitution. Fortunately or unfortunately, depending upon how you look at it, in 1803, in the case of Marbury v. Madison, John Marshall said and implemented the thoughts and thinking of Alexander Hamilton in the case of Marbury v. Madison, recognizing the power of the courts to veto laws repugnant to the Constitution of the United States. United States. Now, other aspects of the judiciary that you should look at is to adjudicate one of the purposes of the legislature or the judiciary. Yes.
Sorry, before you move on to that last point, you started talking about Jefferson a little bit. Can you explain just briefly how Jefferson saw it differently than Marshall? Because it's always confused me on that point.
Well, my expression earlier was with regard to Jefferson and Hamilton. They had striking differences of views on how things should be done. By way of just one example is that Hamilton believed in the national bank and tried to sway George Washington in that direction, and Jefferson vehemently opposed it, very strongly opposed it. That would be an example of those two in opposition, and their views of life, I think, were quite different.
But specifically in that, what was it, 1803 case where Marshall, I thought Jefferson and Marshall didn't see eye to eye, but Marshall more or less won the argument with that court case.
Oh, in that case, when Jefferson didn't even show up to argue.
Well, it was
It was
pretty difficult
philosophical.
because, one of what created the controversy was that as Adams began to live office, he made these several appointments to federal courts, but he signed it, but he didn't seal it and deliver the appointments. And the argument in front of Marbury v. Madison, and somehow they twisted it to get to the result that they needed, which is typical of courts, to endorse and ratify the concept of judicial review and of constitution of things that are repugnant to the U.S. Constitution. I don't know about their personal relationship and how they may have dealt with each other, but I know that Jefferson was vehemently opposed to those appointments, and yet this court case affirmed those appointments made by Adams. And what they did is they took this controversy over here and twisted and turned it into the ability of the judiciary to veto acts of Congress and of the executive in accordance with the review of the Constitution of the United States. Does that help?
A little.
I don't have any great deal of insight. It takes a study to go deeply into that and more time than we have today.
Yeah.
But I appreciate the question. It's good. Very good. One of the things that, what is the fundamental purpose of the judiciary? Anyone? Students, adults? It's fundamentally to keep the social peace, to keep people off the streets. That if I have a problem with Alan, something happened between the two of us, we're not out in the streets exchanging, clubs and guns and that type of thing. It's so that we can go and ask a third party, independent of any other branch of government, to review our controversy and come up with a just decision as to that. And it's interesting about about human nature, which is another subject about our Constitution, which always makes me really thrilled, is, you put that kind of footnote in mind about human nature, is that the reality is if they know that they've been treated correctly, despite they may lose to the ground, they may fall in the process, but there's something about it, they know they've been dealt fairly and their case has been reviewed judiciously, in the true meaning of that word, care and justice, they're settled. It's okay. They'll move on to the next issue in life. But if they know that they can't, they'll turn to the streets to resolve the problem. It's one of the natures of humanity. So one of the purposes of judiciary, especially among individuals, is to set policy between two people, to settle their controversies. One of the purposes of the legislature is to set disputes among the whole population. Pass a law, it settles a controversy, right? But a judiciary is the one that deals with each other on an individual level. Also, what's come about because of judicial review is because there might be two parties sue each other, a state versus another state, or one person against a state. There are two separate parties involved, but they'll issue a decision that impacts sweepingly across all of society. And the function is that, of course, is legislative. That's the abhorrence, besides the absolute horror of Roe v. Wade. And what it's done is in making that decision that involved two parties, state of Texas and Mrs. Roe, or Miss Roe. I met her several years ago at a meeting, and what a wonderful woman. What she came to be. She realized a mistake. But her name escaped me. She's since died.
Say Norman McCorvey?
Yes, Norman McCorvey, wonderful woman.
I remember.
Yeah. Yes, I do. I ran out as she was leaving after her talk. I just shake her hand, give her a hug. I'm very passionate about that issue. And no apologies for that. I'm pro-life, and I think anything else is less than murder. That said, my purpose here is not to get into that. Okay, we're covering the purpose of the legislature, of the judiciary, and part of it is the only way you can really keep justice and peace in society is make sure that judge is independent, and that's what our Constitution does. It uses the term emolument, which means simply the judge is paid, and its pay cannot be lowered for life. It can be increased, but not lowered. And what is the other factor in the Constitution about federal judges?
Good behavior.
Good behavior, that's the standard. Otherwise, they're for life. Thank you. Why is that? Why are those two things? Why for life, except for bad behavior, and their pay?
Judges, once they're put in place, they don't have to worry about getting reelected. They focus on making wise decisions, making just decisions.
Precisely, it's the independence factor that keeps the clarity around them. So they don't have to worry about how am I going to get paid by this. You know, there's a story about Thomas, what's his name? He was killed by the King of England. More. St. Thomas More. He refused to accept the king's taking over the church. Well, he died for that. And they said that during one of the cases of controversies, he was paid by a woman this chalice, this silver chalice. And he took it from her and walked away. He eventually threw it in the river because somebody was trying to buy his favor. It's true here too, but what did the King of England do to the judiciary when things were happening against him? He would reduce their pay and he would knock them out of their seat. How can they be judicious in the true meaning of that word if their job tomorrow afternoon is gone because the king doesn't like me? Because I'm deciding something slightly different than what it should be. That's what we call an independent judiciary, critical to any Republican government from the time of Rome forward to today. If you want a good government, the judiciary is independent. Liberal, conservative, whatever. If they're independent, they'll come to a better decision. I cite the last few weeks, and I believe it deeply, after reading Hamilton. You watch the court is entering several unanimous decisions. I'm going to ask you, why do you think that's happening? Hamilton talks about this, so I encourage you to, this 230 years ago, talks about is that the judiciary needs to be independent of every influence of every other branch. And they start to overwhelm. Why? Because the judiciary has no guards, except maybe marshals out front. They don't have an army to enforce their will. They have one thing that they can do in society that gives effect. What is that? Enter a judgment. And it has to be implemented, correct? So I guess what I'm saying is the Supreme Court of the United States, and certainly the court of the state of Idaho, has no authority outside of their good judgment. What we're seeing now is that I personally believe the justices of the U.S. Supreme Court are pushing back on issues against the Congress and against the President of the United States that want to attack the court. And they are sending a very clear signal that they want their independence. Leave us alone.
had to respectfully disagree with.
That's fine, because I'm expressing my opinion, and I'm not gonna,
That's why.
I don't wanna argue. I think it's a fair argument. I'm not saying it's an opinion. I think an informed opinion, and yours is probably equally informed, but it's just an expression. I think we're seeing the pushback against that political pact of disorder. And why? Because Hamilton touches on it in its nature, is that it has no army, it has no police, it has no way to enforce its judgments, just through persuasion. And that's all I think they're trying to do. Okay, one of the things that I want to answer some questions, and maybe you can engage that. But one of the most valued things I think that you, as especially as students explore the future, is try to understand the founding documents of the United States, and that's an important factor, that the founding documents of the United States, to understand. We talked a few minutes ago about human nature. What is it about tyrannical, socialist, communist governments and their constitution differ from that of the United States founding documents? Anybody venture?
They're founded in the idea that whoever is in charge has ultimate authority, and that person's responsibility is to provide necessities and not ensure property rights.
That society's needs outweighs their individuals.
Yes.
That's one of them, that's for sure. And I think that all of that's together, but I think what the missing element, if you look, the founding document of the United States is the Declaration of Independence, and it talks about human nature and that we're created in the image of God. You will not find that in the implementing statute or implementing documents of other countries. And these Federalist Papers, Federalist Paper number 51 says, once I'm done here, I'll shut up and answer questions. But I wonder, the fascinating thing about our founding documents and those things which discuss these principles is that human nature plays a role in our government. And one thing that James Madison said, and many of you may have heard this, he said, it may be a reflection on human nature that such devices, in other words, devices to limit government, should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls of government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and the next place be in subject to control itself. What he's saying is that human nature itself is simply a testimony of government, and that first of all, its first purpose is protection of life, liberty, and property. Those are its first purposes, its first role. It has nothing to do with the king or its majesty or that kind of thing. It's that it is a government of the people that is implemented by consent of the people. There was a German philosopher and politician in the early 1600s by name Robert Bellarmine. He wrote against the divine right of kings. He and the scholars of England were writing against each other back and forth. And in his document called On Civil Government, it just got translated in English in the last 10 or 20 years. He talks about the consent of the governed, and he cites the Old Testament. Anybody understand why he cited the Old Testament? Because exactly the same thing was going on in the Old Testament. What did happen when the prophet would anoint a man to become king? What would happen next? He would take the king out to the people and acclaim it and see if the people approve. Bellarmine wrote about this and said, it's 150, 70 years before Thomas Jefferson, the concept of the consent of the government, and that the purpose of government has a very limited role. So I bring up those principles just to show that the focus on the judiciary is a focus on making sure that one of its functions is to, in fact, be a check against big government, right? And to limit the role of the implementation of unfair and unjust laws, both at the individual and at a social level, society level. Yes, ma'am.
So I hear what you're saying, and I'm having this conversation about, so where does fear and intimidation and bullying and all that stuff play in all of this? Because really, if you look at what happened with the king back then, they could take the king out and people didn't feel like they had any voice. So of course they accepted the king, even though he really wasn't accepted by the people. So
Well,
isn't that kind of what's happening today in a lot of ways?
well, yeah,
We're forced to accept what's happening in society because if we try to stand up and say things, then there's a lot of things that are happening.
okay, well, that's a fair question, and I think
I don't know the answer. I just,
No.
it's a dilemma that
it's
we're all trying to deal with.
we live in very frustrating times. What I'm doing is trying to touch on theoretic bases and actually practical bases that were implemented by the United States in its early part of its history. And something we always want to look back to from a perspective of not just tradition, but real law, the real law. So it becomes a reference point for those who make the argument that government is outstepping its bounds, is when we look back to how they implemented it. And why is that? Because one of the things about human nature is that it always looks to its tradition, to its history, to what created it. And that certainly we have an incredibly rich history and tradition and documents that can point to us this limited government and the limited function of that government and how the judiciary can be a check against excessive government. Great question. I don't have an immediate answer and all that. I think I love to see personally these, for whatever reason, there's been about 3 to 5 mothers lately that have been on YouTube pushing back against school boards about the extremities of critical race theory or the masks or those kinds of things. And that what some of them are using in their arguments are the founding documents of the United States. And those are very rich precedents to use because there's no defense. Health and welfare always gives government an excuse to expand sometimes. And we need to pull back when the emergency's over. We need to pull back to where we were before that occurred, just like they did after World War II. I mean, I wasn't around then, but the point is very simply that there's a time when the war or emergency is done, government needs to step back to its boundaries where it was before. And maybe that's part of the argument here too.
But the problem is they don't want to. That was their plan, is to overstep and overtake and subdue people.
That's a great question. I mean, that's a great observation. I don't
I
disagree.
mean, I think that's just.
No, I don't disagree with
Maybe
that.
maybe that conspiracy was.
No, there's no conspiracy. It's happening. There's nothing hiding behind some branch somewhere. It is happening. The expansion of government. I think it's a good point.
I really like what you said at the beginning of the purpose of the judiciary. When people know they are going to get a fair hearing and feel like they're going to have a fair opportunity for actual justice, but they will just move on, they'll accept that and move on. And I think a lot of the unrest we're seeing is because people are no longer feeling that sense that there's true justice anymore. And so we are seeing a lot of unrest and people trying to settle their own disputes because they don't feel like justice is being served anymore because we've fallen so far from that ideal. But I think remembering the ideal, learning the ideal is super important to all of us to know that, just like you said, theoretically, that's how it works with the legislature. The money gets spent through the House, right? Like theoretically, that's the way it's designed, and that's a good design. And too many people want to tear out our country and say, let's start over. It's like, no, revive the good design.
Exactly. And this is the beauty of this setting here, is that what is the first exercise of expansive government, especially communism or socialism, is to get this young man here to forget his history, or the young women about us, to forget and abandon. That's why always going back to who we are as a people, as a culture, has incredible power. Because in this country, this nation, I just want to make, in many cultures, they go back and they don't have anything really to dig at, but we do. The treasure of the founding documents and our history and our efforts to seek justice, even where there's injustice, is always a good.
But they're trying to rewrite that history.
No.
1690 project, and with saying that everything you're talking about, everything that we believe, they're saying, no, that's untrue, and that was formed because of racism.
Yeah, I know.
And
And that's why
destroyed.
we do this.
Well, you're making my point.
Yeah.
I mean, that they're trying to destroy tradition and history and that which makes us us. Don't get me wrong.
Change society that isn't
You know,
paying attention.
yeah.
How do you stop?
I don't,
They're more
I don't
interested
have-
in TikTok and Twitter and everything else than paying attention to what's going on.
well, you know what will happen? Is this kind of symposium is the kind of thing that needs to happen. And it is happening. The hearts of American people are being awakened, I believe. Somebody else, yes.
And sticking with the judiciary,
Yes,
as, was it a deputy attorney general that you served as?
I am, yeah.
Or you were- Did you, what was your oath of, did you have an oath of office? Did you
Yes.
take an oath of office? Would you share what that is?
Well,
What
as
that
I
was?
recall, it's uphold the Constitution of the United States and the Constitution of the state of Idaho. That was the oath, and it was an oath. I didn't swear it; it was an oath. So I swore it under God. That's the difference between swearing and an oath. Is that when you make an oath, it's under God.
And so, unless I'm missing something, those two would be the supreme law of the land, U.S. Constitution.
U.S. Constitution,
And the state of Idaho, us being in the state of Idaho. So those two would be the supreme law of the land.
insofar as the Constitution of the state of Idaho applies. Yes.
Have you ever found in your work that sometimes when precedents get set, that sometimes people, the courts look at precedents as the next standard and then forget about the supreme law of the land that's sworn oath to?
Yes. One of the best examples I do not speak for the Attorney General, and I want to make that very clear. I am here as a private citizen, and I have a great deal of love for this country. And I try to do my job in as the best light possible, according to my education and understanding of the founding of this country and where we're headed. With that said, I was appointed as a Deputy Attorney General in 2006. I had that was, you know, when I took the oath of office, I signed it and I considered it. One time there was I'm trying to recall the exact nature of it. But it was my job to, very narrow, I work for, assigned to the Department of Insurance. And my job is to look at violations of the law in accordance with insurance law. It's very narrow. I'm, you know, there's 100 DAGs that work for the state of Idaho, maybe a little less. So my job was looking, they were talking about a kind of settlement. I can't go into any great depth, but the impact would have also impacted this person in the criminal court. And I was afraid that if we went this direction, it might impact his civil rights in the criminal court. So I just simply said, I don't want anything to do with that. I can't do that because I think it would violate the Constitution of the United States, because it was my position that the prosecutor needs to prove the case in court. We're not going to do it for him. And every time we can, we have to protect, make sure within our realm, our little realm, this little place that I am, make sure that people are protected according to their civil rights. That's a great question, but that's one example. It hasn't happened very often, only 3 or 4 times. Well, when it happens and it's comes to you very clear, you push back and see if there is, let's get away from this because this isn't right. Just a second, go ahead.
And the court issues, arguments, like the Mary was talking about, that expand the power of the government and go outside the limited powers that are confined in the Constitution. When they imagine they find things in the Constitution that really are not there. Why is that not defined as bad behavior, and how is good behavior defined in their case of their behavior?
I've never heard that kind of question. It's a great question. Attaching bad decisions to bad behavior, that's an interesting principle. And I think that might be one standard to apply. The question is, though, who's the judge?
That's what who gets to decide.
Yeah, who makes the decision? You know, Hamilton touches on good behavior here, and this gentleman brought it up here earlier. And the way the standard, when you remove somebody from office, is through high crimes and misdemeanors, that kind of thing. And that might be one of the measurements. But there could be also, it's really an unanswered question. There's been very few removals of federal judges over time. There have been definite ones. One, sometimes maybe they're drunk. There was a judge in Southern Idaho back in 1998 in one of the southern counties he was an alcoholic and he was not committing any overt crimes, but he was clearly not executing justice. So the court finally stepped in and sought to that either get out or to go to rehabilitation. And the story goes, I was in front of him one time and it was pretty obvious that there was a problem. So, and I know there were several attorneys that were worried about the situation. He ended up in rehab. And now, of course, it's a different standard at the state level. They apply different rules, but still there's been alcoholics at the federal level and they work through the back door to get them to change. But you raise a great question about bad behavior connected to bad decisions. The problem is that who do you get to judge that? And the judge for that, according to the Constitution, at the federal level is the House of Representatives. Great question.
Which it should be.
Nicely, yes, nicely thought through. Thank you.
One of the themes that we have here for our symposium is the idea that ideas have consequences, words have meaning, question everything. So under the category of words have meaning, just wanted to bring up the word equity because of the way it's being used. It had been used historically in a judicious manner within the context of judiciary. Though it's considered a good word. But now, culturally, that term has been used a different way and it's being imposed culturally right now in a totally different way. And I just wondered if you could address that.
That's a good question. First of all, in the courts and the judiciary, I don't know if you realize, but in the courts of England, there are two separate courts. And one is the court of law, and the other is the court of equity. In fact, that's where the term equity comes from. When you have a mortgage, that's what used to be that if you missed a payment in Old England, you lost your property. And then somebody took a case to court, equity court, and they said, well, you can have the property back, the mortgagor, the mortgagee. But you got to pay them the value of the property, the difference between what the value of the property and the debt owed. So that's actually kind of where that came from. It's a court of equity recognized that the owner had some value in the property and the person holding the debt couldn't get everything. It would have been a wrongful redemption. So that's where that turned from. And then the courts just make it very clear. The courts of equity and law have been merged in the United States. They're not two separate courts. And you can appeal to the equity part of the court when you do go. But the judge sits at in both positions. Now, as far as equity in the law would be very different than how it's being interpreted culturally today. So equity of the law might be equity in opportunity or equity in results. Equal opportunity before the law, or does the courts, or I mean, rather the government in some form or another, be it a court or the legislature, extend equality of results, which is impossible in this world. We live in a world subject to fallen nature, which we have abandoned the concept of, and limited resources. And we cannot implement fully and equitably, I want to use that term, in the idea of equal results. In fact, someone of 100 years ago in the States would have laughed at such a concept because they knew that the concept of equity is I want to be a citizen, to stand up and my hard work to be recognized and I be able to bring home and take care of my family on my own. I think that concept is still alive today. It's just being subsumed by the media. And the beauty of the American people, I am convinced, is this heart for freedom has not and will not die. That's a footnote. To answer your question further is that the concept of equal results is nothing less than a nefarious belief that somehow we can make everything completely equal. All that we can do really, both in law, be it the courts or the system itself, is to make sure that we deal with justice. You look at the issue of races, it has been so run up the pole that it's almost ridiculous. They've made it have no meaning. And there was a time in the United States, when I was very young, my mother was from Mississippi. And I remember going down there and I could not believe how the Black people were treated. It was real. All that has changed in the last couple decades, 3 or 4 decades. But it was a testimony to me, although by that time Martin Luther King was gone, I could see that his arguments had great validity because there was deep, serious division and implementation of the law of equity in the United States. But that has changed. There's great progress. There's still issues, don't get me wrong, but I don't believe this personally, I don't believe it's systemic. But there's things we need to tackle still. But the difference between, if you've been studying, I don't want to go into too deeply, but the critical race theory, which is off mark on what we're talking about.
We've been talking about it.
Well, the big distinction is that, at least as far as Martin Luther King is concerned, is he did what all of you young people are doing here, and the adults are reaching back to the founding documents and making the argument why we should treat people correctly. The institutions of slavery, of segregation, lived before the founding documents, and we had to get them destroyed. And guess what? It cost the blood and guts of 600,000 men and women in the Civil War. Now, I'm not arguing that was necessarily the cause of the war. It certainly became a huge issue. And I'll tell you what, we're still fighting for fairness and equity in the sense of opportunity for everyone. I think we can all make that observation. Yes, sir.
I like to consider myself a self-educated law student to some degree, so I really enjoy reading it. And I had talked to Lawrence Watson one day, and I said, Lawrence, I said, what's the biggest problem you have in the state of Idaho? He said, Tom, he said, you wouldn't believe it, but it's trying to be able to get people to understand policy is not law. And that really, really set me on a really interesting trajectory. It's a really interesting journey to be able to look at things in several different ways. I think an example that might be good for kids to consider today is a mask mandate. whether that's actually law or whether it's an administrative policy. An administrative policy and law, I can't tell you, that I'm an attorney or whatever, but my understanding is the fact that they're not the same. So when you have a bureaucratic agency that tells you that you have to be able to do something, you have to be able to put your thinking cap on today and realize where the law actually comes from. And so my question today for you is, when you were in the AG's office, I understand, or I had to believe that the AG's office is an administrative position, right? So I'm trying to be able to navigate through that part of going, okay, well, if they're involved in administrative policy, then how are they involved in the Constitution? And isn't that a blurring of jurisdictions? Because if administrative policy is not law, then how can you guys make statements on things relating to things outside of your jurisdiction?
I'll try to answer the best I can.
Does that make sense?
Yes, it does.
But I just want to point out, this is going to have to be the last question. We have to keep our eye on the clock here, so just want to.
All right, no, that's actually a really good question. And part of it is, I want to make very clear, even though I Romans 13 and other parts of the scripture tell us to honor those in authority over us, and I honor my boss. But in 15 years of working there, you've talked to him more than I have. It's just reality. That's just the nature of it is. And what I've tried to do is to get to know my area of the law and serve my client, the Department of Insurance, well and hard, because to protect, against the wiles of insurance companies. That's been my job. I have not prosecuted criminally or anything else. I just make it very clear. The other thing is I don't speak for him in any way. I'm here on my own, and I still work for the department as a DAG. But I just want to frame my comments within the reality of who I am and not attribute it to somebody else. And then it would, first of all, the Constitution of the state of Idaho has 7 constitutional offices, and that would be considered mostly the executive branch. You've got the public instruction, superintendent, the DAG, the AG, the governor, lieutenant governor, secretary of state, and the treasurer, I think. And because they're constitutional offices, they exist quite independently of each other, and they think independently of each other. Whereas the AG of the United States is thinking like the president is thinking, right? And the treasurer of the United States, and on and on and on, because they're following his or her policy. So just to make it clear that the AG is not an administrative policy or in administrative agency in that sense. It's the
But
state
he's ruling over administrative policies as well.
Well, no, I'm just trying to answer your question because it's a great question. I'm just trying to make sure that the understanding of the relationship differs from the federal. So when you say administrative policy, it depends upon just if the Department of Insurance has rules, it has its law, which is Title 41 of Idaho Code. It's a book about that thick, and it governs mostly insurance companies. Its whole focus is to make sure insurance is being properly operated in the state of Idaho. And by the way, 2 years ago, they repealed the entire rules and they reduced them down by 60%. But I think if I'm understanding correctly, your question correctly, I might, and correct me, please, if I'm wrong, is that rules are, the rules, the question might be, do the rules have a force of law? And they do, but not to the same extent as the statutes. The court has actually ruled on this. I'm not saying something that is just whimsical, is that administrative rules have a force of law, but within reason. And they have to function within that realm, and it cannot be outside. The state of Idaho has carefully written its laws to say you cannot invent what is not in the statute. So if you look at it's hard to explain, but if I wish I had the code with me, I could read the sentence. Basically, these are my words, but the effect of is the rules have to stay within the reasonable and the reasonable, precise nature of the statute itself. It just needs to explain it. And so I can only answer the question, to my experience is that there is a force of law and it's not whimsical. It has to go through a process of approval and that kind of thing. Does it have the full force and effect of law? No, not of a statute, nor of the Constitution. So I bet if you gave me time in a book here, I'd probably help find the case law on it, but there is case law on the distinction, constitutional, statutory, and administrative rules. Sorry to go over.
Yeah, I'm sorry, we're running out of time because this, I think there's more questions. We'd like to invite you to come back.
Well, I'd love to do that. I just been so gracious and I appreciate your work.
Would you have a minute? You want to just close?
Yeah, I just take a moment is, it's hard to express in my understanding, right now I'm at a retreat. Take this weekend, I'm actually the director for the retreat here, and I wanted to agree to it. One of the things my understanding, in my study of the law and its nature and relationship to religious freedom is so critical. And these documents are full of references to religious freedom and this function of protecting society and who we are. Don't ever forget that. And try to understand the Constitution the best you can, because it will help you live life. That's why I encourage, especially young people, to read a few of these documents, and it's deep. And it looks like old English, but the more you read it, the better. And in closing, it's this. Our society tends to stretch God issues away from public issues, from social issues, from this. But my friends, they're all tied together. We're all circling around. They all depend upon the common good and how God sees us in our relationship with Him. So anyway, and I have no apologies for that, but I encourage all of us to, regardless of our sectarian belief, is to understand that this is so key to the future. My mother-in-law, who, God rest her soul, died 15 years ago fighting for these principles, Helen Chenoweth. And she had such a soul for this issue. She still inspires me to this day to speak out and make it known that we need to move forward on this. This is the perfect defense against big government.